Welcome back to the second segment. In the first segment, we discussed Alok's journey in the profession. And in this segment, we can dive into the recent judgment of the Supreme Court in Union of India versus Mohit Minerals. So the judgment was around a controversy involving ocean freight, right? And that is also discussed in the judgment. But I think the core issue that came to light over here was whether the recommendations of the GST Council are binding on the states. So, sir, the judgment is quite voluminous, and again, tax is an area which most people find complex. So, I was wondering if you could just demystify the judgment, like why did this issue come up, and what is, let's say, a brief history of the whole issue of GST Council, its recommendations, and what exactly does this mean? Like, if you could just demystify that.
Sure. So this is going to be a long answer, so please bear with me. Let's first start by understanding what GST is, right? Now, GST is a transaction tax. That means when when A buys something from B, and A is giving B the money, A has to add an element of tax to it. B takes that element of tax and gives it to the government, right? Uh, this is what is being taxed is the transaction, this actual fact that there is transfer of goods or services and there is consideration in response.
Correct.
What GST does is to say that we're not going to make this artificial distinction between goods and services. All of them will come under the same tax regime. States will tax and center will tax. We'll get into that a little bit later, but just to simplify a little bit, what it is basically saying that we've now moved to a system where instead of taxing goods and taxing services and taxing this and taxing that, we're saying now we're imposing a transaction tax on a bunch of things to simplify matters. Now, it's very simple. If, as in the example that I gave you, goods go one way, services, money goes the other way. What happens if goods, money go in different directions? And this is where it gets a little complicated. I give you a simple example. Within India, supposing, for instance, sitting in Bangalore, I buy something from Delhi, right? I transfer the money online. It goes to the person who selling me the product, and they ship the product to me across the country. Now, this is where something called the IGST is levied because it has moved across borders eventually to reach me.
Hmm.
What about international? All right. Now, international, this is where it becomes a question of import. That is where customs duty is applied. Right. Now, customs is for the good entering this country. Customs is only something that you apply on goods that are entering the country. There is currently no customs on services at the moment, let's say. But that is also a transaction, and that can also be subject to GST. Now, let's come to the nub of the Mohit Minerals matter. Now, supposing you're importing large quantities of goods, right, from overseas, you have to pay for those goods to get transported. Now, those of you who ordered from Amazon will know that Prime is the reason why a lot of people subscribe to it because it cuts out the cost of transport. So Amazon is consuming that cost of transport on itself. It's not passing it on to you. Supposing I have let's say I'm sitting in India. I want to buy something from Turkey. Okay. It has to travel by sea. What I will say is that I am paying you 100 crores for this. Okay. You are selling this to me. I'm going to receive this in India. But because I'm buying it at a rate of 100 crores, why don't you cover the transport cost yourself? So my supplier who's sitting in Turkey says, fair enough, that's a good deal. You're just going to be paying me 100 crores. As a gesture of, well, not as a gesture, it's also practice. I'm going to say, fair enough. I'm going to cover the cost of transportation myself. And I'll just make sure to send you the goods as long as you send me the money. It's just pure import. There is no question of GST here. But as the supplier sitting in Turkey, I will reach out to a company in Cyprus and say, hey, can you provide me ships to transport these goods from Turkey to India? And of course, I will pay you for it. The ships will go from Cyprus to Turkey, pick up the goods and transport them to India, where my Indian buyer is sitting and waiting for them. And I'm going to pay you whatever, 5 crores to make this transaction. Now, obviously, this is between two foreign parties, correct? One sitting in Turkey, one sitting in Cyprus. This is money is going from person in Turkey to person in Cyprus. The service is the shipping, where the ship is going from Cyprus to Turkey and then to India.
Hmm.
Mohit Minerals, what the government tried to do, or rather, this was in 2017, what the government said was that I will levy IGST on the Indian receiver of goods for the transaction that has taken place between the guy in Turkey and the guy in Cyprus.
The 5 crores.
Yeah, that 5 crore part of it. Okay. But because I don't know exactly what that 5 crores is, I'll ask you to pay it on the 100 crores that you've already spent on this. So keep in mind, I'm sitting in India, I've bought 100 crores worth of goods. Now the government is saying to me, on the 100 crores of goods that you have purchased, I want you to pay an IGST by reverse charge. That's what is called reverse charge, right? Now, for those of you who are a little bit more familiar with GST, you'll have heard that lawyers, some of lawyers' work is taxable on is leviable onto GST on reverse charge basis, which is the person who receives that service pays the tax, which is the opposite. In the rule is the person who receives the money pays the tax, but reverse charge changes it around to say that the person who is giving the money also has to give the money to the government. Okay, so now the person sitting in India who has just bought this 100 crore worth of goods is now being asked by the government, please pay this extra amount of money as tax for the transaction which has taken place between Turkey and Cyprus, two entities in Turkey and Cyprus, because by the way, you are the ultimate beneficiary of that particular transaction. Okay. So this, after a couple of rounds of litigation, was challenged in the Gujarat High Court. Gujarat High Court struck it down to basically say, among a bunch of other things, there were 4 or 5 grounds. That's also, it's a much shorter judgment than the Supreme Court's. It goes in depth into the issue as to why this is problematic. But basically, they say that one, this is effectively giving extraterritorial application to GST, right? You're effectively taxing a transaction which has happened between 2 parties outside this country, no relation to this country. Therefore, you can't tax it. And they look at the GST law itself, which is the Central Goods and Services Tax and the State Goods and Services Tax and the Integrated Goods and Services Tax, and say there's nothing in this law which allows you to tax a transaction like this. This is a pure administrative law principle because the government had issued notifications saying that you will tax them accordingly. The court looked at the definition of supply of service, looked at the definition of various other things and said nothing in this law allows you by notification to collect tax for such a transaction by issuing a notification. All right. This is the Gujarat High Court judgment in Mohit Minerals. It's authored by Justice Pardiwala, who's currently in the Supreme Court. And for somebody who's interested in GST, it's a good way to get introduced to it because this is one of those cases, like how I've just described. It starts from the simple and goes very quickly to the complex. But because once you understand the simple, you can actually understand the complex also fairly easily. And because very fundamental concepts like what is the GST, what is service, what is supply, all of those are discussed in the judgment. I would say that for people who want to better understand the Supreme Court judgment in Mohit Minerals, they should also read the Gujarat High Court judgment, which it kind of agrees with but overturns a couple of findings. I'll get into that later. Now, obviously, the union government was aggrieved because a bunch of exporters had filed a challenge, including the company Mohit Minerals themselves. And they felt that the Gujarat High Court judgment was wrong and they approached the Supreme Court. Now, in the Supreme Court, the union government took a novel argument, right? Because they hadn't raised this before the Gujarat High Court. And this is an argument based on the interpretation of the Constitution. So, and it's a purely legal issue, so you can raise it in the Supreme Court. That's not an issue. They raised the argument that the GST Council, right, which is composed of states and the center, decided that such transactions should be taxed, and therefore the central government, which is bound by the recommendations of the GST Council, issued this notification. which meant to say that unless you're like challenging or saying that the council's recommendations are unconstitutional or something, you can't really just challenge the notification alone for being against the statute, because the notification draws its authority from the recommendation of the GST Council. So this is again, it's not a tax argument so much as a administrative and constitutional law argument. Okay. So, I mean, according to me, any law which restrains the power of the state is constitutional law. It's just that we draw these very artificial categories in different matters. But I'm just keeping that so that our listeners, who I assume a lot of law students and lawyers and so on, will stay on board. The essential argument, to repeat, was that GST Council has said this kinds of transactions should be taxed. We are only carrying out the mandate of the GST Council, which is, by the way, binding. So even if the act wasn't amended, we are still required to follow it, and therefore you can't strike it down. This was the argument which was taken. A bunch of other arguments, I won't get into it, otherwise it will become just a discussion of Mohit Minerals. But the Supreme Court responded by saying actually GST Council recommendations are not binding.
Correct.
Now, this is where the tricky part comes. The court looks at the way the GST Council functions. In the GST Council, as I mentioned, both the states and the union are represented. Their decision is supposed to be taken by majority, but it's not one entity, one vote. All the states put together account for 2/3 of the vote. The union alone accounts for 1/3 of the vote, which means that it's not a one, as I said, one entity, one vote. Majority doesn't mean 50%. Majority means 75%. So if you just do the basic mathematics, all the states put together will not be able to pass a decision or a recommendation if the union does not agree to it. But the union and about half the states can agree to something and be considered binding or be considered passed. This meant, according to Justice Chandrachud, I'll come to my own views on this. This meant that states could be made to follow a recommendation that the union wants, but the same kind of thing is not binding on the union. So his view was that this goes against the basic structure principle of federalism in this country. And two choices were before him. One, he could strike down the amendment introducing GST 101st Constitution Amendment for introducing such a clause which will compel the state legislature to follow the directives of a body, or he could interpret it in such a manner so as to make it non-binding, right? And leave it to state legislatures in the union to figure out how to implement it. He chose the latter option. And in that context, which is why we have the judgment of the Supreme Court in Mohit Minerals, which says that in the context of GST Council recommendations, they can only be non-binding recommendations. They are not binding on the union and the state. But if they so choose to, the union or the state can make appropriate amendments to the legislation to say they will mandatorily be binding if they wanted to, but it will not be presumed constitutionally that it will be binding. Therefore, the union could not rely on the recommendation of the council saying that please tax ocean freight on a reverse charge basis for the Indian recipient of the services. It will be struck down, and a bunch of other findings are made in the context of extraterritoriality and the context of the legislation itself. I won't go into that specifically because we want to discuss a few other things. So this is what the Supreme Court held in Mohit Minerals. The main finding, of course, the one which obviously the parties are most interested in, is saying that you can't levy by reverse charge service tax on ocean freight. That's one. But most importantly, and the one which has caused the most concern perhaps among the commentariat and the government and so on, is the finding that recommendations of the GST Council are not binding. So this in sum and substance is what has happened in the Mohit Mineral case. And we'll go on to more aspects in a little bit.
Yes, sir. So I mean, even you have been cited in this judgment by Justice Chandrachud. Like he cites some of one of your paper which was published in the NLS review, if I'm not wrong. I mean, we'll put a link in the bio for those who wish to read it. And I wanted to get your views on one of the arguments that Justice Chandrachud provided. He said that, and this is a term that's used often, that India follows cooperative federalism, right? And that the whole GST model, the whole GST council model, was predicated on the idea that all the states come together, discuss, negotiate, cooperate, and then come up with policies. And that if this was not the case, and if the union government could do whatever it wants to, along with just brute force, then this whole cooperative model would break down. So how would you respond to this? Let's say, like, do you agree with this argument? Do you have disagreements? And what exactly is cooperative federalism, and what interplay does it have with this particular controversy?
So let's go back a little bit and sort of see the vision that the founders of the constitution had when they created India's constitution. When a lot of people first read the constitution, and you'll see this coming through even in the Constituent Assembly, a lot of people don't think India is a federal country at all. They're like, this is some kind of federalism. But look at how many powers are there in favor of the union vis-a-vis the state. And you can't really say that this is like a federal model. But over the years, it's the understanding of federalism which has changed. At its core, federalism is saying that both the national and the subnational units of governance draw their powers from the same source. It's not as if one is delegating to another, right? To take two extremes, right? In the US, powers are given, which is considered a federal country in that way. US constitution gives power to states and to the federal government. Whereas in Britain, it's all devolution. It is the parliament giving powers to various authorities, whether it is to the parliament in Scotland or to the various local councils and so on. It's not as if there's a common written constitution, which is the source of this power.
Correct.
Not to say that UK doesn't have a constitution yet. Of course it does. But the source of that power is not a common constitution. That in that way, you can't say that the UK is a federal system, even though it may have subdivisions, they may have lawmaking powers. You won't call it a federal system in the same way that the US was. If you were to plot all of this on a spectrum, you'll realize India actually lies closer to the US than to the UK, even though we have adopted a Westminster style of parliamentary democracy. In the initial period, people were not very sure exactly how our federalism would work. But I mean, it's changed so much in 70 years that the initial few years seem like they have come from a different planet entirely, not even the same country, you would think. Cooperative federalism is a concept that has evolved over years. And I'm speaking specifically about the Indian context. The idea that states can stand on an equal footing with the union on such matters is a relatively new concept. You would not have said this about India in the 70s or even the early 80s. Perhaps in the late 80s that this idea really started taking hold. I would put this down to the way in which the Bommai judgment reconceptualized federalism, but it was also because I think there were changing currents politically. A lot of regionalist parties were rising. You had Telugu Desam, of course, you always had the DMK, the Dravidian movement in Tamil Nadu, but you also had parties like the TDP come into existence. You had various regional movements gain more strength, gather more autonomy for themselves in the constitution itself. I mean, everybody talks about 370, but look at 371A to the most recently 371J. All of those are the result of movements, and some violent, some peaceful, saying that we want more autonomy for ourselves. And that resulted, of course, in the reconceptualizing of what the Indian Constitution really is. That's called asymmetric federalism. But over the years, it has evolved to become this. India's federalism has evolved. We are not talking about an originalist idea of what India's federalism was, but what it has evolved to become. And you find this in various institutions, in various processes, in various systems, which have gradually reduced a little certain level of union control over the states and giving them a little bit more position. I would say now we don't consider it revolutionary because we're used to it, but something like VAT, each state had its own state tax, sales tax on various goods, on various rates and so on. But under VAT, in 2002, a mechanism was set up where states could coordinate their rates. The idea was to eventually move to what has now become the GST, but this would not have been possible if states hadn't started getting together and coordinating along with the union. The union couldn't tax goods, except in a very limited set of cases. But the idea of sitting together at the table, discussing tax policy, cooperating, arriving at consensus was set in that framework. And that was not constitutional. Like, it wasn't put in the constitution, but it had a certain status in the way in which VAT worked, that people agreed to it and were bound by it. When it comes to GST, right now, this is where we skip a few years ahead. The initial idea for the GST came during, or at least the GST amendment bill, let's say, came during the UPA 2 regime. And that bill wanted to give constitutional status to the empowered group of ministers under the VAT regime, right? Where states would sit together and resolve. And of course, put the union there, make it more clear, because the union had to be a fundamental part of it, because you were going to tax goods and services. Services was exclusively within the union's purview, goods are only within the state's purview. Now you wanted a uniform transaction tax, which would cover goods and services. The initial idea was that this GST council would have to exist as a coordinating body if we want the same tax rates, the same classification, the same procedures, the same administration to apply across the country. Initially, the model was that the GST council would undertake consensus-based decision making. So in that way, it would be a recommendation, because you already agreed that you will follow this. As a state, if you have said, yeah, this works for us, you've already agreed, you've already bargained, you've done whatever it is and followed it, and it becomes consensus. At some point between this initial draft and what was eventually passed as the 101st Amendment, a change took place where this consensus was replaced by majority voting. Now, I've tried my best to locate through documents when and where this happened. The first time this change is mentioned is during the Rajya Sabha Select Committee hearings, sometime in, I think, 2014, late 14 or 15, where Mr. Sushil Modi, who was then, I think, heading or the deputy of this empowered group of ministers looking through the GST, who says that we have made this change because we think it will be easier. That's about it. Nobody offers a solid justification as to why we are moving from consensus to majority voting. This is only noticed by the Tamil Nadu Chief Minister, Ms. Jayalalitha. It is also pointed out by the members of the AIDMK in the Rajya Sabha and the Lok Sabha when the debate happens. It is also mentioned in the report, the final report of the Select Committee, Joint Parliamentary Committee, I think it was. Please correct me if I'm wrong. Which they put in dissent note saying this voting structure is wrong. It shouldn't be as I've just described it. It should be consensus based. There should not be weighted voting. It should not be by majority. And it is fundamentally unfair to state this point was made in the reports of the Rajya Sabha and on speeches in the House. But eventually the GST amendment, the 101st Amendment, was passed in the form that we know it today. Coming back to Mohit Minerals, in going by the evolution of the understanding of federalism, the idea is that states and state legislatures are quote unquote sovereign in the fields allotted to them under the Constitution. They pass the laws because they want to, because they have been elected to do so, not because the union tells them to, or they're directed, or Parliament has made them do so. Where Justice Chandrachud's concern comes in Mohit Minerals is that if we make the GST Council's recommendations binding, it will basically mean that another body is sitting on top of state legislatures, and even perhaps, but never on top of the union legislature, right? So you suddenly realize how from being at the same level, suddenly state legislatures are falling a little bit below when it comes to GST. There is another body in the middle which directs them to say pass such kinds of laws or make these kinds of changes to the governments also. So his concern was that this goes against the very idea of federalism in this country. Cooperative does not really describe a constitutional mechanism. It's just a way in which states and center works. But under our constitution, interpreting it this way would have created a situation where the state legislatures and state governments would be bound by what this particular body said where they might not have agreed to it. They may be in the minority, but they still be bound to it and they'll follow it because they effectively the union is telling them to do so. So in that context, what he has interpreted as state is only not binding. But here's my counter argument, and this is what I say in my NLSIR piece. GST cannot work on hopes and prayers. It cannot work on good wishes and gentlemen's handshakes, as they used to call them. It needs a legal framework where there is certainty that when the GST Council agrees to do so, it will actually happen. It won't be left for the individual states to figure it out. Because here is what happens next. If a state says, I interpret this in this way, and other state says, I interpret this in another way, then this is ripe for the source of dispute. So then how do you dispute this? How do you challenge it? How do you bring a certain level of uniformity? Keep in mind, this is one of the key things which makes or breaks GST. It is uniformity. And the uniformity is not just about the rates. If I produce something in, let's say, Karnataka, it is sent to a manufacturer in Maharashtra, and it is eventually sent to a retailer in Gujarat, right? A GST cannot survive, even if the same rates are there, but the way in which something is seen in Karnataka is different to seen in the way in which it's seen in Maharashtra, and it is different in Gujarat, right? That uniformity is essential. I should clarify here that it is not only the constitution and the law which ensure a level of uniformity. The mechanism by which GST is collected and assessed also ensures a level of uniformity. You have a GSTIN, you have a network on the basis of which people make their payments. That money is routed through RBI and comes to various state governments. There are other laws, for instance, the compensation scheme, which the union has agreed we will give you compensation 14% and so on and so forth. So that framework for uniformity is wider than just this particular GST Council recommendations. I'll accept that. But this is so fundamental that when conflict starts to emerge, for one, you don't need to resolve this conflict because you can always say majority voting. I will outvote you. I will have more votes, and you can't have your way because I can veto it. The effective veto which the union government gets, keep in mind the numbers. You need 75% for any vote to sail, but the union has 1/3 weightage, effectively giving it a veto. So which means the union can say it's my way or the highway. And that is the source of the problem. Because if it is purely a recommendation, then what's the point of voting? Right? But if it is binding, it creates this other problem. And this, to me, is the fundamental problem with the GST amendment itself. With due respect, the Mohit Minerals judgment has tried to put a band-aid on it. And band-aid will last for a while. I'm not saying tomorrow the whole thing will fall apart. But right now it has not yet been subject to such serious stresses and strains that will test the strength of this bandage. There will be a time, I foresee in the near future, when there will be serious stresses and strains, when some states will find this compensation mechanism isn't enough for us. We need more. And the union will say, we don't have more money. Where are we going to get it from? And the states might just be tempted to say, fine, all our recommendations are only binding. I will tax this, I will tax that, I will add this, I will add that, I will deny this particular input, I will not give input credit, I will not give that exemption, and I will be collected myself. The other possibility is that certain states might have industries which other states don't. Like, we know textile industry is very heavy in Tamil Nadu. We know, for instance, that automotive industry in Rajasthan, which is now like growing in that Thanesar area. I'd say, these guys actually deserve more of an exemption than we want to give an exemption to grow this industry. So we will tamper with the GST structure that has been agreed upon to grow this industry here. So that sort of, there are already these powers incentives to mess with the structure. And that might people might now see, okay, fine, we'll not disrupt it too much. Why should we? But at some point, the pressure might get more on them to say, either one, you're running out of money, or two, there are strong local lobbies which want you to work in their favor. So I believe we will start seeing these strains and pressures on the GST Council. It will not obviously crumble overnight, but the idea that the GST Council or the GST system can work with the Council's recommendations being only general recommendations, I don't think will give the GST a very long life.
Right. So in fact, sir, actually just a couple of years ago, at NALSAR, we had hosted senior advocate Arvind Datar for a talk on GST and federalism. This was way back in 2017 or 18, if I'm not wrong. And in fact, it was back then that he told that in effect, in the possibility that you have 29 different GST regimes in the country, with each state being a GST regime of its own.
Yeah.
So you agree that this is a likely possibility in, let's say, the near future, or this is something that in practice you don't see it happening in the near term or a long term future. Like, I mean, forgetting the possibility aside, like keeping aside the possibility, going by the culture that exists right now, the tradition and the practices right now, how do you see the near to long term future of like the GST Council and fiscal federalism in this context?
If things don't change, I think what Mr. Datar fears or suggested might happen. Maybe not all 29, 30 states, because not a lot of states have the mechanism or the wherewithal or the capacity to do that entirely by themselves. But it just takes, like, okay, India is also one of those highly unequal countries that way, where some states have disproportionately large economies, population, and so on. If I were to take the belt of states between, say, Uttar Pradesh to Tamil Nadu, right? If they were to say we'll get our own GSTs, whole thing is gone. You will not have a GST left. You even if these 12, 13 states, like let's say UP, Rajasthan, Gujarat, Madhya Pradesh, Maharashtra, Karnataka, Telangana, Andhra, Tamil Nadu, 9 states. I think they account for possibly more than 3/4 of India's economy, if not more.
Yes, sir.
If they say bye bye GST or bye bye to the GST as we know now, it won't stand. Right? So you don't even need 29 different GSTs. You need basically these states to feel this is not working for us. We are not having a say in what things happen. We are facing the negative consequences of it. Why this is not working for us? Because let's also understand, state balance sheets are stressed. They were stressed before the COVID pandemic, and they are now even more stressed. States are taking more and more debt. Now, obviously, the union guarantees all of these debts so that it's not like any one state in India can go bankrupt. But you don't want to be in a situation where people are like, hey, it's been 3 months since I got my last salary in state government employees. What is going on? You don't want to be in a situation where you're like waiting for, and this is what the situation Karnataka has been in the last few months. They'll be like, we're hoping for the union government to send us the transfer of this. It might work if the same parties and power in both the union and the states. But the moment there isn't, or you have an antagonistic relationship, the mechanisms will break down. They might be just like, why should we go begging with a begging bowl? Or even if you're like, you may arrange it within the party, people may still be upset and frustrated. They'll be like, again, to take the Bangalore example, since I live in Bangalore, people may like, why aren't the roads getting fixed? Why isn't the suburban project moving? Why aren't, disbursals from this scheme and that scheme not happening? It won't do to say, yeah, we're waiting for the union government to give us money, because people will say, then we'll rather have a government which won't wait and will find a way to get this money, right? So this is where I think it will come under stress. This is going to be a problem that the GST mechanism is going to face. I think the time is now to fix the fundamental drafting problem with the 101st recommendation. You either have consensus and recommendations, according to me, right? And there's no middle way. You can put all the bandages you want, but there's no middle way. You can either have consensus and call it recommendations, because you're already agreeing to what you want to do, or you can have majority and binding. GST will survive at either of these ends, right? There may be certain issues either way. There is a way to make it majority and binding also, which is not forcing union will on the states and so on and so forth. That is also fine, because even with majority and binding, we are finding that by and large, most decisions have been taken on the basis of consensus. I think except 2 or 3. It was, I think, nearly 36 or 37 meetings before the first time anything had to be put to a vote. Everything was done on the basis of consensus.
Correct.
I think this Mohit Minerals judgment has shown that now is the time to fix this fundamental problem with the GST Council. Personally, I feel it does Indian federalism more justice to have a consensus mechanism and say, call it recommendations. You won't need a dispute resolution body. You will not need any way to conciliate or mediate, because now the pressure is on the parties to negotiate. Because let's not assume it's center versus state. It will be state versus state by and large. The so-called producer states and so-called consumer states, they will have different interests, but they're not irreconcilable, right? You may have to say, okay, fine, we won't do this for now, but let's see if situation changes and we'll do it later. That is part of the process of what makes a GST work. Other countries, for instance, enter into an agreement. Australia, for instance, where the states have a lot more power of taxation, they enter into an agreement with the union to say this is how we will tax, and they consider it binding among themselves. So that way, this is what I think is an opportunity right now. Fix this problem so that tomorrow, when the stresses start to come forth, they can be absorbed by the system rather than have the band-aid flow apart and everything falls apart. So this is where I think we are right now, and I think to avoid the kind of future that Mr. Arvind Adar painted in the lecture that you mentioned, this is what the government needs to do, to say, yes, I think what this has shown up is a serious problem. We won't brush it aside just because his judgment has said, oh, you'll sit together afterwards and figure it out. I think this has to be figured out in the GST Council itself. So let's choose one of these which works best for us. Either we say it'll be consensus and it'll be recommendations, or we'll say majority voting, but no veto for the center and it'll be binding. So I think that is where we are right now.
Right. So, I mean, there's definitely a lot for us to think about over here. And while we'd love you to, we'd love to have you for many more different, discussion, taxation or otherwise, because, you write on several different issues, but I think we have a paucity of time today. So thank you so much once again, sir. And I mean, we look forward to you offering the constitutional aspects of taxation course again at sometime soon at NALSA.
I hope to.
And I mean, as a soon-to-be Chief Justice has said, he was reading a lot of articles that have been written about Mohit Minerals. Who knows? Maybe he might be watching this as well.
Yes.
So yes, sir. Thank you once again. And yeah, it's been great to have this opportunity to interview you.
My pleasure, Anurag, and all the best. And I look forward to continuing our conversation in various fora.
Yes, sir. Thank you.
All right.